Hello folks, welcome to the Edupedia world and I am Abhinay Gupta. Today again we'll continue with the topic, the appointment and qualification of directors. The first chapter from the topic directors. You have 3 chapters on directors as we have already discussed, right? We have already had few lectures on this topic and that we have understood the importance of the chapter, right? We have understood the flow. What are the things that we'll be learning in this chapter? Right, we have seen the difference between executive and non-executive directors. We have seen what a company is and why does a company need a director. Right, we have gone further to see other topics like only an individual can be a director, or we have seen section 166. We have seen the limitation on the number of directors that a company can have, and also the number of directorship that a director can hold. Right, now today we'll move a step ahead. We'll try and understand the qualifications and disqualifications of directors, which is covered under section 164. Do we actually have any qualification for director? The answer is no. Anybody can be a director of a company. Seriously, anybody. You can be of any age. You can be from any background, science, commerce, arts, anything. You may not have any experience. That doesn't matter at all. Right? The only thing you need to become a director is a director identification number. Right? And you get it from the government, from the MCA website. So anybody can get the DIN, and once you have the DIN, you can be a director in any company you want. Right? There is no limitation, there is no qualification required to be a director. There is no degree appointed for that. But you certainly have some disqualifications, right, that can restrict your directorship. So section 164 of the Companies Act 2013 is read along with the Companies Rule 2014. To be very specific, the rule is the Companies Appointment and Qualification of Directors Rule 2014. These two combined, they don't lay down any qualification for being a director. But yeah, what they do is they negatively stipulate the eligibility requirement for becoming a director by providing for certain disqualifications. And now the disqualifications are divided into 2 parts. One is the disqualification that comes on to the director, and the other is the disqualification on the director by reason of the default of the company on the whole. Right? It is not important and it is not personal to a director. Right? So to start with, we'll understand the basic grounds of disqualification on the director that lie upon him individually in his individual capacity as a director, right? And that is contained under section 164 subsection 1. The first disqualification that surrounds a director is being of an unsound mind. If a person is of an unsound mind, right, and he also stands so declared by a competent court, right? How do you prove he is of an unsound mind? It is when a competent court, a court who is competent to declare a person of being of an unsound mind, if that court declares a person, any director, to be of unsound mind, that director stands disqualified. So he will not be able to hold the office as director anymore. He'll have to vacate the office and will not be eligible for reappointment or appointment somewhere else. Right? So the first criteria of disqualification is of unsound mind. That can be considered as a qualification. So if a person is not of an unsound mind, if he is of a very sound mind, he is eligible to be a director. Right? Along with it, the second point that we have is undischarged insolvency. So if a person is an undischarged insolvent, that means the person was insolvent, right, and he was so declared by the court. Now he has come up from that bankruptcy. Now he is solvent again, right? But we will not consider him to be solvent unless that insolvency that was charged upon him is taken back by the court. So once the court declares that charge to be taken off, to be pulled off, right, then he will be considered as solvent. So if he is an undischarged insolvent, so far as he is not discharged, he will continue to be disqualified from being the director of a company. Right? The third is a person who has applied by himself to be adjudicated as insolvent. Right? So this talks about a person, a director, who has given an application to be adjudicated as insolvent, and that application is still pending with the court. So in point number 2, who is covered is the person who has been charged to be insolvent. The court has declared him to be insolvent. That person is covered under the point number 2, right? But what about the person who is insolvent but is not yet charged by the court? Then how do we know he is insolvent? That we know about it when that person himself gives an application to the court to be adjudicated as insolvent. So for the time period between his application to the court considering and declaring him insolvent, during that time period also he will stand disqualified, right? Further, a person who has been convicted by the court, but this does not include all convictions, right? The specific conviction that will be included in this will be if a person is convicted for any offense of moral turpitude, right? And that should not be very normal. It's not about an offense for which you have been given an imprisonment for 2 to 3 months. No. It has to be severe enough to deserve an imprisonment of greater than 6 months, right? Where you have been awarded an imprisonment of 6 months, right? And that incidence is not very old. Say 5 years have not lapsed. Till then you are till then you are disqualified. So once you are convicted by the court for any offense of moral turpitude, right, and you have been sentenced to an imprisonment of 6 months or more than that, right, you will stand disqualified for that period of 6 months, and when you are discharged, you will still be disqualified for the period of extra 5 years. So if the imprisonment is less than 6 months, he is not disqualified. If it is more than or equal to 6 months, he is disqualified for 5 years. But if the imprisonment is more than 7 years, right, then he will be disqualified for lifetime. So 0 to 6 months, no disqualification. 6 months to 7 years, disqualified for 5 years. And then 7 years to infinity, he is disqualified for life, right? Then the next point that we have is, if the order of court to disqualify is in force. So there can be cases when a director is disqualified from appointment as a director, or any person is disqualified from appointment, or a person who is already appointed is now disqualified, right, by a court or a tribunal, and that order that has been passed by the court or tribunal for disqualification is still in force. So long as that disqualification order continues, the person will stand disqualified. Now, any directors we know, they have to hold qualification shares in many cases, right? So, and otherwise also they can hold more shares for the company. So consider an example, if there is a director and he holds some shares of the company, right, and there is some call money due, right? So if this director fails to pay the call money, right, for the period of 6 months from the last date which is fixed for the payment of the call. So if the company fixes the last day for the payment of the call to be 31st March 2014, right, and the director does not pay the call money till the end of September, like 6 months have lapsed and still he is not paying the call money. So with the end of that 6 month, from the next very day, from the beginning of the 7th month, that director will stand disqualified, right? Next is any disqualification attracted due to section 188. Now section 188 is a section that refers to the related party transaction. So if there is any person who has been convicted for any offense which is regarding a related party transaction, right, at any time during the preceding 5 years, he would stand disqualified. Remember, he has to be convicted for this offense, right? And if that offense is more than 5 years older, like he committed an offense in the year 2000, and now he has been given a conviction by the court. A court has convicted him guilty for an offense in 2000, and he has been convicted in the year 2010. So 10 years have lapsed. So that will not attract disqualification for him, right? So the period of 5 years, 5 preceding years, is also very important. right? You'll have to pay a deep attention on this too. And when we discussed about qualification, the only qualification that a person needs is holding a director identification number. So as per section 152(2), if a person has applied for a director identification number then but has been rejected or has not been allotted then by the government. So if any person is not allotted then he cannot be a director because he doesn't have a director identification number, right? So how will government keep a track of the person, of his acts, of the documents that he is signing? They'll have no track because you'll have to mention DIN, and that is what helps the government to keep a directory for you. DIN is for a lifetime, right? So if you don't have a DIN, you stand disqualified, right? So these are the disqualifications that are attracted to a director, that if attracted to a director, he will be disqualified from being a director. He will be disqualified from reappointment or from appointment somewhere else, and he'll have to vacate the office, right? So section 164 subsection 1 does not provide for any qualification of director but negatively stipulates the eligibility requirement, right, by providing for these disqualifications. So it is very simple. It is very easy to keep in mind also. The person is of unsound mind, undischarged insolvent, applied to be adjudicated as insolvent, or convicted by court for offence of moral turpitude, for imprisonment greater than 6 months, and 5 years have not lapsed. There are 4 points in this specific 1 point, right? And the order of court to disqualify, if court or tribunal has passed an order to disqualify, if that is still in force, or if that director is not paying call money, right, and he has also been given a time frame for 6 months from the last date of paying the call, and even then if he doesn't pay, he is disqualified. And if he is convicted for any related party transaction, if he is convicted in the preceding 5 years, and if he has not been allotted then by the government. So these are the cases that will attract disqualification for this person, right? So next these are the disqualification in his personal capacity, that the director is disqualified as a person. Next, in section 164 subsection 2, we'll see the disqualification that is attracted to a director by reason of being a director of a company, and these disqualifications are actually meant for the company on the whole, right? So disqualification for default made by company is covered under section 164(2). So over here, as per the provisions, a person will be disqualified for 5 years if, and what does disqualified means? That he will not be eligible for reappointment as director in that same company, or he will not be eligible for appointment as director in any other company for a period of 5 years. If, right, if the company of which he is a director, if that company does not file its annual statement or annual return for any continuous period of 3 financial years, the company stands default and the director stands disqualified. So it is important to note that the director is disqualified if the company makes this specific default, a default of not filing any annual statement or annual return, right? Any one of them. Maybe a company is regular in filing an annual statement but is not filing annual return for 3 consecutive years. There can be any 3 consecutive years. Then the company stands default and the director stands disqualified. So consider a case where a company ABC Limited has not filed its annual return and annual statement for the year 2000, right? So it stands default for the first year. Again, it does not file the same in the year 2001. It remains default for 2 consecutive years now. And before the end of the 3rd year, before the company being default for the 3rd year, if director Mr. A vacates the office as director and then the company defaults, so he has been a director for 2 years 11 months, 2 years 11 months 29 days, right, and then the company defaults, will he be disqualified as director is the question to think about, right? So this has a clear interpretation. If the company defaults for 3 consecutive years, the company is a defaulter and the director is disqualified, right? But if the director vacates the office before the company gets into this default, he will not be disqualified because he is not a director of the company at the time of default by the company. Now consider an example. Mr. P joins the company just 1 month before this disqualification before this default would be attracted to the company, will Mr. P be disqualified? The answer is yes. So if we understand the provision of 164.2, it is entirely different from the provisions of 164.1. In 164.1, the director specifically had to be individually a defaulter. He had to be individually convicted. He had to be individually disqualified. But in section 164.2, all the directors of the company, at the time when the company is declared a defaulter, all the directors at that point of time in the company will be disqualified. No matter if the director is involved in that default or not. That is a separate issue altogether. All the directors of the company for that specific period when the company makes the default, that particular time when the company makes the default, will be disqualified. So that is one default on the end of the company, and that is for the consecutive period of 3 financial years. The second default at the end of the company would be if the company fails to repay public deposits taken, or fails to redeem the debentures on the due date, or fails to pay the dividend after declaring them, and such failure continues for 1 year or more. So over here you have been given a time period for just 1 year. If you have made any of the 3 defaults, if the company has made any of the 3 defaults in repaying the public deposit, in redeeming the debentures on due date, or in paying the dividend after declaring them, if that default is made good within a period of next 1 year, it's all good to go. But if that default is not made good and 1 year lapses, then all the director on that day would stand disqualified. So again, that particular day is very important. If you vacate the office before that, you're safe. If you join the office before that, you're caught. Right? It is as simple as that. Now, apart from this, there is one more very interesting point. That is that if the company that has been a defaulter, right? If that company makes good the default that it has entered into, will the directors be qualified again, considered to be qualified again? The answer is no. Once the disqualification is attracted for the director, he will remain disqualified for the period of next 5 years, no matter when the company makes good the default, right? So company makes a default, director is disqualified. But if company makes it good, director is not relieved of that disqualification. They will still continue to be disqualified for the period of next 5 years. So these are the basic provisions for disqualification, 164.1 and 164.2. And to continue, the article of any private company can also levy upon them any additional ground for disqualification. Right? They can have certain more points as per the requirement of the company, as per the discretion of the company. Right? They just amend the article, or they put it in the article in the very beginning that these are also the clauses for which our director could stand disqualified, then they will stand disqualified for the same. So what we have seen so far would be applicable on all the private company, and for the public, for all the public company and private company, all of them. But for private company, they can have additional grounds too. And there are certain other provisions contained in the rules for 2014, the company's appointment and qualification of directors, rules 2014. So as per that provision, any director who is supposed to be appointed with a company will have to give them a declaration. He'll have to file an intimation with the company in Form DIR 8 before his appointment that yes, he is not disqualified as per section 164 subsection 2, that disqualification is not attracted on that person. Right? Because other disqualifications can be, disqualification of section 164.1 can be very easily verified. Right? Because that is attracted on that person himself. But this disqualification is due to the default of the company. So that has to be, for this specific thing, the declaration has to be given by the director himself. And then as per that rule, there is another bad news for the directors, that if the company makes a default, then the company will have to intimate the name and addresses of all the directors who are on roll for that company during that period of time within next 30 days to the registrar. So even if you try to escape, you cannot, because it is the liability of the company to inform the registrar for the same. That these are the directors who are being disqualified due to my default now. So you are again trapped over there. And then what does the registrar do? The registrar keeps them open for public inspection. right? They'll immediately register such form and keep it for public inspection, open for public inspection. And any application, if the director wants to give an application for removal of such disqualification, he will have to give an application under form DIR 10, right? So these are the provisions of the rules. Which rules? The company's appointment and qualification of director rule 2014, right? Now further, can these disqualifications be postponed? So not all, but certain grounds of this disqualification can be postponed, right? So in the case where the court is involved, where the court gives where the court convicts a person guilty, right? Those disqualifications can be postponed because now there is an involvement of the court. So what are the three disqualifications that are attracted, like in which court is involved? The number one is disqualification order in force. If the court has ordered a director to be disqualified and that order is in force. Number two is disqualification referring section 188, that is disqualification attracted due to any default in the related party transaction, right? Next was obviously the conviction by the court. So in these three cases, the disqualification can be postponed, right? And what is the time period? For how long can it be postponed? So it can be postponed for 30 days initially, right? But during the 30 days, if an appeal petition is filed, right, within that period of 30 days, before the lapse of that 30 days, if any appeal petition is filed with the court, then the disqualification will be postponed till that petition is disposed of by the court, right? So if you can see the pink arrow, so until that petition is dissolved, is disposed of by the court, that will be the total period of postponement. Till then the disqualification will not be attracted because that is not proved, right? But even after its disposal, the person will be given 7 more days for grace, right? After 7 days the disqualification will be attracted to him, right? So once it is disposed of, there is a buffer period of 7 days and then the disqualification will be attracted. Now this 7 days is another opportunity for that person. They can file another petition, another appeal, right, to be secured. They can file another appeal to any other court, and now the disqualification will be postponed till the disposal of that appeal. So at the end of that appeal again, if the person is considered disqualified, then there is no further postponement. That director will be disqualified now. But if after that appeal if that conviction, if that offense, right, if that blame, if I talk about, if it is taken away by the court, right, if the court gives the director a clean chit after the disposal, so the disqualification will never be attracted, right? So once the disqualification is attracted in above 3 cases, there will be a postponement of 30 days initially if you file an appeal till the disposal of that appeal, right, with 7 days buffer. If within that 7 days another appeal is filed, then till the disposal of that appeal. This will be the time period of postponement, right? So that will be all for the day today, right? We have learned a lot about disqualification and qualification of director, right? And we'll continue with the other topics in the upcoming lectures. So until then, stay tuned. This is Abhinay Gupta signing off. Thank you. Bye-bye.